everybody. Welcome to Justice Served Daily. Hello to all the justice warriors who are watching and anybody who is new coming on and checking this out. I want to just share some information in this recording. So I'll let you know right now this is already pre-recorded, but for some reason StreamYard likes to send it out like it's alive. But anyway, I wanted to get this out a little bit earlier, but that did not end up happening. But I wanted to make sure to get it out because I'd started working on this and then had to stop for a little bit and get back to it in order to get some information out and help with some other cases that are actually going on in addition to, obviously, other than just Delphi. And because there's a lot of cases out there that also need help. And I want to make sure I do my part in doing that. So let me go over. I'm going to share my screen. And I may have to do this for entire screen. I'm trying to think here. But I will do this and see what happens. And actually, let me go make sure I also did the sound. I would just want to double check. And I'm glad I did because I don't think I had originally pressed that either. So I wanted to go over some information with you, just talking about some famous cases that I'm sure most everybody has heard of, even if you're young, younger than these cases, which I was sitting here thinking, wow, these can't be as old as I think they are, but actually looking back at them, they really are. But I wanted to really address information about defense teams and that they can lie to create reasonable doubt for their clients. And, really talk about some famous cases to do that. And also just kind of briefly touch on what's coming up Monday. Technically, in a little while, it'll be already Monday. But we've had so much going on and so much craziness with all the repeated filings back and back and back and forth. And then all of the stuff that is coming out from different people who have had to go forward to share information and others who decided to kind of push themselves into this case, which is making me so sad and about what's going on. And, so let me remind us of a couple other cases. And I'm not going deep, although I will say after I kind of revisit them, these cases were cases for myself that I really paid attention to as most of the country and honestly, across the world, definitely for O.J. Simpson and maybe even for, Casey Anthony. But, I want to touch briefly on those, but I really made me think, those may be good cases to kind of retouch with. So if you guys have an interest in that being done, just let me know and we can go back and cover this. But I do want to talk about these cases just as an example. And I have some details and stuff, and we've got, O.J. Simpson and his dream team, right? That's famous of his attorneys, including one of his own personal friends. And what was that case supposed to really be about? It was supposed to be about Nicole Brown Simpson and Ronald Goldman. And if you're too young to know about this case, one, don't tell me because I don't want to feel that old. But two, O.J. Simpson was an athlete who had many times abused his wife, Nicole Brown Simpson. And it came forward that there was a birthday of one of their daughters that he attended a recital or something like that with. And then they all decided to go out to dinner, meaning Nicole Brown Simpson with the kids and all that. They were going to go to a restaurant that O.J. Simpson's son was working at. Nicole Brown Simpson decided not to and did not invite O.J. to that. And they went out to dinner with her mom, with her kids, and that. She decides to go home. Then she has Ronald Goldman, who finds out that her Nicole Brown Simpson's mother left her glasses behind, and he decided to bring those glasses over to Nicole Brown Simpson's house. And when he gets there, wrong place, wrong time, but he ends up murdered along with Nicole Brown Simpson, who they were brutally stabbed. And, a whole ordeal of that. And again, you can go look into this. Definitely, if anybody wants to hear more and us to even talk about the case altogether, just let me know. But the point of here is just talking about stuff with the defense teams and what can go on. And one of the biggest things for this, and this shows you how long ago it is. So if you're old enough to remember this, then you're as old as I am, and you'll go, oh my God, look at the date. And, yeah, that's how long ago it was. June 15th of 1995, and the infamous gloves. So they talked about the gloves, had the gloves. They were, glove was found at the scene and that. But I want to show, again, these are going to be, 4 or 5 minute clips that I have just to show a couple real quick, just of this and the information that we then find out of how the defense team, who insisted that the prosecution would let OJ try these on, basically already knew that they weren't going to fit. But let's watch the live as this came on in court.
Was there a model or style of glove that you shipped to Bloomingdale's exclusively?
Yes.
Ms. Bemich, who are you employed by?
Bloomingdale's.
Let me show you the glove that has been marked. Item number 9, the Rockingham glove. And this glove is exclusive to Bloomingdale's?
Yes.
Okay. Looking at that glove, can you tell us the name or the style?
The right hand of style 70263.
And what style number was that?
70263.
Which glove?
Eris Leatherlight glove.
During 1990, how many Eris isotoner Leatherlight gloves, brown in color, size extra large, did Bloomingdale's purchase?
Approximately 300.
Have you ever seen it sold anywhere in the world other than in Bloomingdale's?
No, I have not.
Is that a Bloomingdale's credit card sales receipt?
Yes.
So the gloves I showed you in court today then fit the descriptions given on this sales receipt?
Yes.
And is there a signature on the credit card receipt?
Yes.
Can you read that signature to us?
Nicole Brown.
Your Honor, at this time, the people would ask that Mr. Simpson step forward and try on the glove recovered at Bundy as well as the glove recovered at Rockingham.
And I think so the jury can see. I'll ask Mr. Simpson to stand. That's People 77. Right.
Have a problem with placing the glove on his hand?
Sustained. This is People's 164A. Is that the right hand glove? All right. Thank you, counsel.
Was there a model
Sorry
or
about that.
style of glove that you shipped?
Doesn't ever want to stop.
Was there a model or
See, so the glove didn't fit. You saw that, but then here's the famous line from the defense. Now, I want to point out that there were a lot of issues with the case. There was a lot of stuff going on. We did have a police officer who was shown to be a racist of one of the police officers, detectives that was on scene. But there was blood evidence, and there was these gloves that one was found at one home and one was found at the other home. I'd like to point out that I have been actually out there and had somebody who drove me from where O.J. Simpson lived to where Nicole Brown Simpson lived. And I'm going to tell you that, you know, they always made it sound like it was so far away, and it was not. It was very quick and easy to get from one place to the other. But here's the famous lines that happened because of that.
Didn't fit. Remember these words. If it doesn't fit, you must acquit.
So that was
Didn't fit. Didn't fit.
So the Dream Team had insisted again that the prosecutor allow O.J. Simpson to try on those gloves, knowing that he had stopped taking medication, taking his arthritis medication, basically for over a month. And I'll show you that clip here as well. Well, sorry. Let's go back to the beginning of it.
And now he is in full OJ acting mode. Oh,
OJ had rheumatoid arthritis, and he took anti-inflammatory medicine prescribed to help him with that arthritis. I was told by Robert Kardashian that OJ stopped taking his arthritis medicine about a month and a half before that issue would come up at trial.
not fitting. And now he is in.
So we've got, sorry, wants to go the other way. So what happens in addition to that? We also have that, you know, so he gets, it's the famous, he is acquitted from that. And there's a lot of people who believe he got away with murder. I will let you know, in my opinion, I think he did. And then he wrote this famous book, the I Did It book. Let's look at this.
Claims he agreed to write this controversial book because he needed the money. The book, If I Did It, describes how Simpson would have hypothetically killed his ex-wife and Ron Goldman.
The publisher called me up and said, I have a project that you can't talk to anybody about. It's O.J. Simpson, and I'm going to get a confession. And she said, we have to present it hypothetically because he's not going to just come out and contractually tell us he's going to confess. But I know that eventually you'll be able to get him to confess.
When OJ wrote the book, If I Did It, I told him I thought he had done something incredibly stupid, and he agreed. He said to me, I know it was blood money, and everyone had written books about me, and everyone had made money, but me.
I just find that disturbing when we hear all about everybody who is writing books for Delphi before it's over, not it's over, their own theories, whatever. And he was acquitted. And it is still a non-solved case. I do want to point out that that book, though, he was sued, not to make money off that book, that a killer should not benefit from a book, is basically what Nicole Brown Simpson's parents sued for. And the benefits and stuff of that went to them because they did sue civilly, and they never got the money from that. So let's talk about another case. And as I go through this one, again, it's very quick, but I'm going to go through and show you some stuff that we know that the defense team is accused of for contempt, what's gone on there. But I'm going to show you again and remind you of the first press that they did that they weren't supposed to, going to talk to the press. And I'm going to show you an interview with them both together, and then I'm going to show you an interview with them separate. So hang in there. We're getting there. Just got to go through this as a reminder. So Casey Anthony and Jose BIAEZ. Again, a disturbing case that just is heartbreaking. Again, if you don't know about it, about this woman who murdered her daughter. And the last time the little girl was seen, including Casey Anthony, but the last time that Kaylee Anthony was seen was on Father's Day, when they went to go visit Casey Anthony's grandfather. Cindy Anthony, who is Casey Anthony's mother, was with them to go see him. She gets in an argument with her daughter, Casey Anthony. And after they get in an argument, because she found out that she's been stealing money, and was stealing money actually from the grandfather as well, and including herself. And she talked about filing charges and stuff against her. And so Casey took off with their car and Kaylee, and they never saw Kaylee again. She was gone for over a month, and they didn't know what was happening, what was going on. They were trying to find her. Then they get a phone call about that the police found the car abandoned, and they had to go pick up the car. So 31 days later, Casey Anthony shows back up, and there's no Kaylee. But Casey was out partying, living it up, staying at her boyfriend's house, staying at other people's house, and then nobody knew where Kaylee was while this was all happening. So let's listen to this 911 call that Cindy Anthony does when Casey returns home without Kaylee, and it was been more than a month.
What says the defense, noted in previous objections?
Subject to just previous motions and objections, Judge.
Be admitted into evidence of defense objections as states numbered.
There is a stipulation as it relates to the accuracy as well.
Ladies and gentlemen, I will read to you the following stipulation. On July 15, 2008, Cindy Anthony made a recorded call to 911 that was received by the Orange County Sheriff's Office at 21:41:20 hours. The recording is a true and accurate representation of the call. The parties have agreed to this fact, and it should be considered as true in your deliberations. You may publish.
Sorry, drinking water.
I called a little bit ago, the deputy sheriff said I found out my granddaughter has been taken. She has been missing for a month. Her mother finally admitted that she's been missing.
Okay, what is
here now?
Okay, what is the address that you're calling from?
4937 Hope Spring Drive. We're talking about a 3-year-old little girl.
4937 what?
Hope Spring, HOPESPRING Drive, Orlando. My daughter finally admitted that the baby's in the store. I need to find her.
Your daughter admitted that the baby is where?
But the babysitter took her months ago that my daughter's been looking for. I told you my daughter was missing for a month. I just found her today, but I can't find my granddaughter. She just admitted to me that she's been trying to find her herself. something wrong. I found my daughter's car today, and it smells like there's been a dead body in the damn car.
Okay, what is the 3-year-old's name?
Kaylee, Caylee, Anthony.
Haley Anthony?
Yes.
Okay, is she white, black, or Hispanic?
She's white.
How long has she been missing for?
I have not seen her since the 7th of June.
What is her date of birth?
8/9/2000. Oh God, she's 3. She's 2005. George Kaylee's missing. Kaylee's missing. Casey says Danny took her a month ago. She's been missing for a month.
Okay, I understand. Can you calm down for me for just a minute and I need to know what's going on, okay? I'm gonna try and tell. Is your daughter there?
I'm on the phone with them.
Is your daughter there?
Yes.
Can I speak with her? Do you mind if I speak with her? Thank you.
I called them 2 hours ago. They haven't gotten here. And he finally admitted to Danny took her a month ago.
Ma'am.
She's downstairs to talk. They want to talk to you. Answer the question. Hello?
Hello?
Yes.
Hi. Well, can you tell me what's going on a little bit?
I'm sorry?
Can you tell me a little bit what's going on?
My daughter's been missing for the last 31 days.
And you know who has her?
I know who has her. I've tried to contact her. I actually received a phone call today, now from a number that is no longer in service. I did get to speak to my daughter for about a minute.
Okay, did you guys call and report a vehicle stolen?
Yes, my mom did.
Okay, so there's been a vehicle stolen too?
No, this was my vehicle.
What vehicle was stolen?
It's a 98 Pontiac Sunfire.
Okay, I have deputies on the way to you right now for that. But now your 3-year-old, okay, your 3-year-old daughter is missing. Kaylee Anthony.
Yes.
White female.
Anthony. Yes, white female.
3 years old. 8/9/2005 is her date of birth.
Yes.
And you last saw her a month ago.
31 days. From 31 days.
Who has her? Do you have a name?
Her name is Zenaida Fernandez Gonzalez.
Who is that? Babysitter?
She's been my nanny for about 1.5 years, almost 2 years.
Why are you calling now? Why didn't you call 31 days ago?
I've been looking for her and have gone through other resources to try to find her, which was stupid.
Okay. Can you give me the name of the nanny again? Like spell it out for me?
Zenaida, Zenaida.
Last name?
Fernandez. - Gonzalez. I think the officers are here.
The officers are there?
Yes.
Okay, hold on a second. Don't hang up with me yet. I need you. Okay.
Okay, let's take a 5-minute recess.
So here we have that before the trial is going to happen. Let me make sure I didn't skip past something here. Right. So let me make sure.
And just Casey.
So basically, Jose Baez tells in advance. So this is the defense attorney that tells Cindy Anthony and them that they're going to throw George Anthony under the bus in advance, right? So she knows this. This is a kind of a picture thing from the show. It was on A&E, and basically Cindy shares that she already lost her granddaughter, and then so the only person that she had left there was her daughter, and she didn't want to lose her too. But this was her basically saying that the defense had let her know that, so that they're going to lie.
In the pool, lifeless, panics. The reason she brings George into it is because who did Jose say he was going to throw under the bus to save Casey's life from the death penalty and life in prison? George. Based on the fact
this is what she's saying in her own words now. There's no Jose Baez sitting next to
but
her.
Jose is the one that put the idea in her head.
Why is she's acquitted? She doesn't have to tell the story. You see what I'm saying? So why is she?
No, I think Casey has thought about that over the years. Created it in her mind to cope with Kaylee's drowning on her watch. Does that sound reasonable to you?
It does sound reasonable.
But that's the negative truth, George. They're in the pool, lifeless.
Sorry, I don't know why it keeps wanting to do that. So they sit here, throw him out of the bus. The part of the story is that now they're saying that somehow, which, by the way, if you don't know this, George Anthony was a retired cop. So they're trying to say that Casey wasn't watching her daughter, the little girl got drowned, and then George was like, oh my God, look what you did. And then they went and, he was part of covering up that she drowned or whatever, instead of, trying to perform CPR or calling the authorities like he would do. He's going to sit here and cover this up. And so she ends up buried where they used to bury Casey Anthony's animals, over near an elementary school that's not far from their house. And this is Jose Baez lying to the jury, and creating the reasonable doubt. Right? He's giving the other scenarios to the jury of what can happen. Now, yes, that's the job of the defense team. They're going to throw these things out there, check what sticks to the wall and what people believe. But he doesn't just throw George Anthony under the bus. He throws the person who found the body under the bus too, because he has to explain the timing of how everything was found and where it was actually found. So let's watch that.
Than just Casey. Rebecca Medina has been following this story from our newsroom today. And Rebecca, fair to say Anthony's attorney threw a lot of people under the bus today.
Well, Jameson, two of those people one of those people were the meter reader who found Kaylee Anthony's remains and George Anthony, the accused killer's father. And that bombshell you mentioned, Casey Anthony claims her father sexually abused her, and that's why she lied. Defense attorney Jose Baez wasted no time painting a picture of sex abuse, lies, and dark family secrets. That picture is his attempt to explain why Casey lied about knowing where Kaylee was.
This child, at 8 years old, learned to lie immediately. She could be 13 years old, have her father's in her mouth, and then go to school and play with the other kids as if nothing ever happened.
George Anthony sat stoic as Baez called him a child molester. Casey Anthony came apart.
The defense, number one, has to answer the question as to how she died. And then number two has to answer the question of why she lied.
Local criminal defense attorney Tim Taylor said the defense did its job revealing why she lied. But Baez wasn't done. He explained how Kaylee died. He said she drowned in the family pool. George found her and helped Casey cover it up. George denied all of it.
Have you ever sexually molested your daughter, Casey Anthony?
No, sir.
Were you present in your home when Kaylee Anthony died?
No, and when I heard that today, it hurt really bad.
BIAEZ brought up Roy Crunk. He said the meter reader took Kaylee's body and hid her until he was ready to collect his reward money.
They're going to say that because this individual had access to the body for a long period of time, that any physical evidence that comes out as a result of that is going to be tainted.
The prosecution fired back with promises of forensic evidence and witness testimony, but it was clear the defense claimed an early victory. Still, Taylor said BIAEZ must now deliver by lining up Casey's story with the evidence. The question everyone is asking now is whether Casey Anthony will take the stand in her own defense. The pundits are saying in light of all of the new allegations, she needs to take the stand. We'll all find out soon enough.
She didn't. She did not.
And just Casey. Rebecca Medina has been
Sorry
following.
about that. So we have that she was not charged with anything. She was released. All along, the parents of that, the father never believed his daughter. The police found she lied that she worked at Universal Studios. She didn't have a job. She stole money from her friend. The only thing she served time was for stealing checks from her girlfriend because she stole money from her. She stole money from her own mother. She stole money from her grandfather who was in the nursing home facility that they saw on Father's Day. So the difference in this stuff is that the attorneys who are in there have to create reasonable doubt. And I use the word lie because they have to create something that is the alternative to that. And that when somebody goes in and they look at evidence, they have to decide. And many of us know a lot of cases that, you know, you're thinking with common sense. Do people use common sense anymore? We used to not have forensic stuff, right? And people had to figure it out, and based on I won't even say the right word. A lot of evidence. I'll put it that way right now. And so that's what they did before they had forensic anything whatsoever. And, you know, whether it's DNA forensics, electronic forensics, all this kind of stuff, the job of the defense team, of course, is to make sure their client is found not guilty. And that is their job in the courtroom to the jury. Okay. So let's going to look at the first video for the Delphi murders is going to be this. I'm going to show you two videos back to back. The first video I'm going to show you basically is going to show, these are going to show violation of their word, not yet of a gag order. So everybody talks about information that got out here, there, or whatever. So you have to remember that we've got Richard Allen, who was arrested, and then the press conference happened on October 31st. And then we have basically, you know, not many days later, we have these meeting, the initial hearing that was done with Judge Gull and the prosecutor in order for them to take on the case and stuff themselves. And when they did that, they talked about a gag order. The prosecution had talked about a gag order. And so Baldwin and ROZZI, sorry, I want to call him the wrong name. Baldwin and ROZZI basically had said, don't have to worry about this. We don't want to try this in the media. And so that it was unnecessary for her to do that. So they didn't need to find this. And so they go through this, they go through all of it. Don't do a gag order. We don't want a gag order. We don't whatever. Well, I want to remind you that not only did they come downstairs and they answered some questions and try to appear this, but there's a difference between when the second interview, the first interview and the second interview. I want to show you those. So I want you to take a look at this. And obviously we need to remember that this case is about Liberty German and Abby Williams. That's what this case is. So let's go to the first interview after they just told the judge they're not going to try this in there, okay? But there's no gag order. So, you know what I mean? They didn't violate it. It's their word, but they did not violate a gag order when they first did this. This is 6 days. And why are we here, right? We're here because of the leaks. It's because of a continuous pattern of leaks, according to and allegedly being stated by the prosecutor, McLeland, who filed the charges, right? And we know the whole thing. We know it ended up at the Indiana Supreme Court. The Indiana Supreme Court did not find that Baldwin and ROZZI were not leaking. They found that Judge Gall could not just remove them from the case in the way they did. Although she technically didn't, because Baldwin didn't want to stay for that case to go out there and to hear publicly about him being scolded about what had happened, which we never got to hear what happened and what evidence McLeland had about that and in regards to that, because the Indiana State Police did an investigation about it and found out what was going on, what was happening, where this all started, which got us Mitch Westerman, right? Well, so the Supreme Court was like, no, they stay on the trial, whatever. And during that hearing, if you remember, and I pointed it out at the time, one of the members of the Indiana Supreme Court said, what is to stop from, we put them back in place and they go back, and then if the judge files something against them and the person defending them had said, well, there isn't anything, she could still do something like that, right? So the charges were put in by McLeland to file contempt against them, and it was due to the leaks. So they go back in there, there's more stuff found out, and then more stuff keeps happening. And we're going to get into that. But let me get to this first video for you guys to see, because I think you're going to find it interesting when you rewatch it. It's always good to go backwards in a case, right? To re-see. So this is the first video, and this is with both of them. Okay, they were not immediately in place. They were in place. This was done on November 22nd of 2022. They were only the attorneys for 6 days. This is Gull was put in place. Remember, she's a special judge. Diener had been stepped aside. He wanted to recuse himself from the case. They picked Gull. They finally ask for attorneys to be assigned. She assigns them to have it. They have to fill out the application. And here we go. Let's watch this one.
Save time. Sometimes you got to be in a courtroom to get that done. It doesn't happen as easy over email. And so I think that was kind of a byproduct of what you saw today.
How's your client doing through all of this?
It's tough. It's tough for him. I mean, we just spent 20, 30 minutes with Rick, and he misses his wife. He misses human connection with people. So it's been difficult for him. And again, I don't know what we're allowed. I don't want to be violating any. We do not want to go awry of the judge here. And but thank you for asking. Rick is doing not terrifically, but he's staying mentally tough right now.
How heavy a lift is it to try to sift through what the judge said is voluminous material that I'm assuming a U-Haul is going to back up to your office and get a hand truck and dump it in your office?
Well, it's not rocket science. That it just takes manpower and time to sort through all this. But we've got staff that can assist us with this and try to vet the stuff that's important and weed out the stuff that's not. And I mean, it's just look, that's what lawyers do. That's what our staffs are used to doing. And I don't really think there's really more to say about it than that.
You think you're going to go March 23rd?
In terms of the trial?
Yeah.
I think we all know where we are with Anybody that's hung around a courtroom for any period of time would probably be able to draw a conclusion about where we are with that.
You guys plan to ask for bail to be granted?
No, we have a bail hearing set, and we're going to use that.
The state has a burden at that hearing, February 17th. So we'll be ready to roll. We'll be asking for him to be released.
You think you got a solid chance?
I mean, these are difficult things to win. We won one fairly recently in a different county, and so it is not impossible, but the odds are stacked against you the way the law is set up. But the state has they have certain burdens to meet, and we shall see if they are going to be able to meet those burdens.
When that discovery lands on your desk and you two guys are sitting there, what's going to be the first thing you're going to flip through and say, we need to look at this thing very first?
I think those are the areas that the judge does not want us to comment on. And I mean, you heard her say in court, this is voluminous. And it is voluminous, and thousands is not even, that's probably a way underestimation of where we're at. And we've been told there's even more discovery coming. So
Talk about just quickly how a logistical undertaking, a change of venue is to have to go to a whole other county somewhere, get that jury, bring them back here, sequester them. I mean,
Sure. Well, you heard the judge mention that, we're going to, I guess from a brick and mortar standpoint, proceedings going to carry out in this county. And I think it's a logical conclusion. And a lot of that is it's just trying to deal with all the moving parts and not have to cause burden on other people. Of course, the most important thing here is that we get a veneer, a jury pool that we can be assured is fair and not prejudiced and unbiased. Like that is the goal in terms of where this case goes from a jury standpoint. But the rest of it seems pretty obvious to me that moving an army of people to southern Indiana is probably just it's not the best use of taxpayer dollar, and it's also just logistically difficult for all of us.
Yeah.
Did you get your money to hire your investigator?
We don't have an order on that yet. So.
All right, and let me point out right here, I just noticed that I put the header and forgot a Z in Rosie's name. That irritates me, but that's okay. So I'm going to show you the next video. This one is
save time.
This one's going to be about this is a separate interview, and I think you're going to find it interesting because they're not together. They go to Rosie's first, and you can tell Rosie's kind of very pulled back, very, cautious of what he's going to say. Again, remember, they've only been there 6 days. They have the probable cause. They tell you they don't have discovery, right, in the first interview. They tell you that that it's minimal to even just say that there's thousands of pages they're going to be getting and that there's more discovery coming. So they're aware of all of that. And here's what's interesting. I also want to point out a couple things. There's this particular recording shows a pause. The reporter is walking from Rosie over to wait in particular for Baldwin. And you hear her say something to the other reporter with her, kind of under her breath. This is the one who, I'm just going to point that out to let you hear that. And why, that's why she wanted to talk to him. And then you hear him talk, and there's going to be a question from the side of somebody asking Baldwin about Kegan KLINE. And at first he's going to say, no, whatever. And then later in the interview, you're going to hear him then say about Kegan KLINE and, that he doesn't even know who that is. Yet he quickly answered this question. And then he's bringing up about a podcast, and he wants other people to help him get info. So I want to just point all those things out, because then you'll kind of maybe pay attention to it when it is brought up, because, after I watched it, and then I had to kind of go back and watch it. And if you have to, rewind it and the show and listen to it. So I want you to catch this and see what your thoughts are. Remember, they just told the judge and the prosecutor they're not going to try this in the media. And by the way, there's no gag order yet, right? But this isn't just the only part that they did. As we saw and reviewed, they literally released a written press release. You have to write those and then send those out to all the media. So physically, there was a press release written to the media about the lack of evidence, all this kind of stuff, giving all that stuff out to the media. And after they just said all this, okay, but let's watch this, see what your thoughts are.
Time with them, really meaningful time, so that's just not something I can comment on.
What do you think about the prosecutor saying they have good reason to believe that he's not the only one involved in this?
Yeah, those comments certainly caught my ear. But again, it's too early to comment on those kind of things just because we don't really have enough information, and I don't think that's professionally prudent to just start, throwing thoughts around without really having the discovery in its entirety.
Does the PC document reflect that?
I'm not going to talk about that. That's
Sir,
exactly what we were just dealing with.
Would you just say your name for the record, please? It's on here.
I feel like I'm in a courtroom.
Sorry,
My
just for
name
our
is
camera.
Brad ROZZI. It's pronounced It's pronounced Rosie, not Rozzi. I'm not going to get into all the nuances.
That's all right. And so
But there are Rozzies around too.
so that we get it right, spell your last.
ROZZI.
Thank you so
Okay.
much. Appreciate it.
I'm going to have her sign it. Thank you.
Now listen to this as she walks over there.
I'm going to get a longer one.
What's it?
He didn't talk through it, I think. I couldn't see the second one really. But this one is the one who did. Yeah, yeah.
Huh? Oh. Is this one?
She's very good. It's supposed to be very, very quick. Yeah.
Thank you so much.
Sure. Absolutely, we want the PCA read, just like my co-counsel Brad said at the end of the hearing. The prosecutor and the police for the last number of years have been conducting teleconferences and asking the public for help. Now we're asking for the public for help. You're going to read that probable cause affidavit online or wherever they get it, and hopefully that's going to ring a bell for somebody to help us out, because he is innocent. He has told us that very emotionally. He has thanked us for our help. And we are anxious for the public to read this. We are anxious for this thing to get going. And we'll see. And when you guys read the PCA, presuming that the judge grants our motion, you will have to question, is this what happens after 5 years of an investigation? Is this what it is? We don't have any other evidence. We don't have any discovery. That's all we have. And we are not impressed.
When you say this would help you get it out, how would that?
Well, you never know what person out there might read something and it might ring a bell. It might cause them to point the finger in the direction of the actual killer. This whole business of the two people being involved, the conjecture from the prosecutor today was new information for us. I've been on this case, folks, for 6 days. So I don't know a whole lot. We have not seen the evidence, and another person involved. I mean, that's new news. So
That's not reflected in the PCA?
not the PCA that I read. Not the PCA.
Do you have any information about the potential involvement of KLINE in this case?
I have no information about that.
Why do you think it's important for the public to see this probable cause affidavit?
Again, I think it's important because somebody might read something, a line about, you're going to see maybe about a vehicle or about a person or about a time frame, and it might ring a bell, something that they hadn't thought of before. And when they read that, then they can contact us as his lawyers. We're getting lots of information
from lots of people across the country, especially locally. We don't know what his hoax is. We don't know what's true. We don't know if it's a podcaster's, opportunity to get in the limelight. We don't know what's real, but we're going to look at every single person that contacts us. We're going to contact them, everybody, and we're going to figure out if what they know is helpful.
What, if anything, has your client, Richard Allen, said this has impacted him and or his family?
Obviously, this has impacted Richard and his family tremendously. I mean, his wife is just a wonderful person, and she loves her husband. They've been married for over 30 years. They were basically high school sweethearts. They love each other, and she fully supports him, but it is devastating. She's scared. She doesn't want to leave her house. She did leave her house. She thankfully is in a little bit better place than she was a month ago, but this is all new to them.
Can you say anything about why investigators are focused on your client?
You guys will read the probable cause affidavit, and you may wonder why they are focused on our client.
We haven't asked you the fundamental question, and that is, your client's the wrong guy?
Our client's the wrong guy.
And what's the main point that you hope the judge takes away from your argument today?
And we have no know is helpful.
What, if anything, has your client, Richard Allen, said this has impacted him and or his family?
Obviously, this has impacted Richard and his family tremendously. I mean, his wife is just a wonderful person, and she loves her husband. They've been married for over 30 years. They were basically high school sweethearts. They love each other, and she fully supports him, but it is devastating. She's scared. She doesn't want to leave her house. She did leave her house. She thankfully is in a little bit better place than she was a month ago, but this is all new to them.
Can you say anything about why investigators are focused on your client?
You guys will read the probable cause affidavit, and you may wonder why they are focused on our client.
We haven't asked you the fundamental question, and that is, your client's the wrong guy?
Our client's the wrong guy.
And what's the main point that you hope the judge takes away from your argument today?
And we have nothing to hide, and transparency is important in government. It may be weird for defense lawyers, I suppose, to be arguing that we want things unsealed, but that's how confident we are in our client. That's how confident we are that the evidence contained in at least what's written in the probable cause affidavit is nothing for us to worry about. We don't know what other evidence is out there, but we're confident that whatever is out there is not going to be enough to show that our client did anything here. He's confused. He's bewildered. Rick, you guys all call him Richard. He actually goes by Rick. Rick is bewildered. He's confused. He has no idea why this is going on. How can an innocent man be accused of a crime like this and have their life upended? That's the kind of stuff that we've talked about with him. And the same can be said for his wife. How can an innocent man be charged, accused, and basically convicted in the court of public opinion is what they say. But what I said to him is, there's plenty of people out there that are supporting you. We're getting a lot of calls from a lot of people that don't believe that Rick is the guy.
Should Judge Frankel keep these documents sealed, how do you guys proceed?
Well, it's like my co-counsel Brad ROZZI said, you cannot conduct a suppression issue in public without talking about the facts. Tiptoeing around the facts is going to be impossible. That's another really terrific reason why these documents need to be unsealed.
In America, you don't have to prove that somebody's the wrong guy. They have to prove he's the right guy. Could you just elaborate on why you say he's the wrong guy?
Well, again, I'm early on in this case. I've looked my client in the eye, and he's looked me in the eye, and he's told me what he's told me. I'm innocent. Thank you for helping me out. And we'll see what the evidence looks like. The PCA, the probable cause affidavit, we are not impressed.
Can you tell us more about what the prosecutor said regarding a second person who might be involved?
Well, that was news to us. So whoever was in that room listening to the prosecutor talk about a second person, that's news to us. I got to tell you, I don't know a whole lot about this case. I'm learning and learning and learning. There's people that have podcasts and all kinds of stuff that seemingly think that they know more about this case. And certainly I'm glad that I'm coming into this case without a whole lot of knowledge about anything. I don't have any preconceived notions. I don't like to look at evidence with some preconceived notion of what it might mean. I don't know what anything means, but this second person business, that there's another person involved. I think I had heard something on a podcast. Somebody had told me that there's a podcast or a news article that says something about that. There was somebody, you mentioned the name of somebody, I don't know who.
KEGAN KLINE.
KEGAN KLINE. I mean, you may think I'm, an attorney. How do I not know who KEGAN KLINE is? I've heard the name, but I don't know who KEGAN KLINE is. I don't know if that might be the guy that did. I don't know. I don't know anything about anything other than, I got a guy here who says he's innocent. All right. And what I would say a very flimsy probable cause affidavit. Those are the two things that I do know.
Do you think they don't want the probable cause released because it's, in your words, flimsy?
I'm not sure why they didn't want the probable cause affidavit. He made his arguments, I guess, and I'll take him for his word that, the prosecutor's trying to protect people, and I respect that. The second person, the investigation is continuing to go on. Again, that is something new. I'll take the prosecutor at his word that those are the reasons why. When I say flimsy, what I'm talking about, I'm a defense attorney that's handled, I don't know how many murder cases over the years. I've got many pending right now. You expect more than what we saw. We're not impressed with it. Maybe they're holding things back that might change my mind later on, and I might have a different opinion. But at this moment in time, you guys are going to be reading it soon if the judge grants our request or denies the state's request, and then you'll form your own opinions as well.
Would you say your full name, please?
Andrew J. Baldwin, BALDWIN.
And the name of your firm?
Baldwin, Perry, and Camish.
So you hear him bring up, right? You hear him bring up KEGAN KLINE and being asked about KEGAN KLINE. And he says no, but he doesn't say to that reporter, who are you talking about? I don't know. Then he says, well, I heard on a podcast, or somebody told me about a podcast and about KEGAN KLINE. Then they're talking clearly about a second person involved, and they're talking about all that. They've only been there in 6 days. Now they're doing their job. I'm not going to argue that point, that's what they're supposed to do. They are, no matter what, they're supposed to come out and say the guy's innocent, right? That's a norm. They all do that. That's what their job is. They're supposed to tell everybody that their person is innocent, but they hadn't seen the evidence yet. They come out there. Now, I want to remind everybody also that when this information did get released, there were still pages that stayed sealed. There were 19 pages of documents that was not revealed when the document drop happened. Now, is there more than that at this point? I don't know. I'm sure they're not going to tell us what's not being dropped, but they definitely told us from the beginning there was some pages that were not, and out of a certain amount, they only released something. So I looked into this info and wanted to pull just some things up for you. So let's talk about what the misconduct after the gag order part stuff happened. So accidentally, we have, after this happens, meaning those guys are interviewed, you saw where I feel like ROZZI is much more cautious than Baldwin is in how he's answering questions and what he's implying. But after all of that happened, and then a written press release is sent out from the office and sent out to all the media. After, again, they tell the prosecutor and the judge, we're not going to do that. We're not going to try this in the media. So that's out the door. So what else do we know that happened? And I can tell you this from some stuff that I know. So there's an accidental leak email from Baldwin to a potential witness for the defense. Now, if you caught this because you watch YouTube and about when this guy came out, Woodhouse, he came out with case details and of discovery that he said was sent to him. He went on his YouTube channel. He spoke all this stuff out. He was a person who had sued the jails and stuff out here because guards abusing him and stuff while he's in jail. or in the prison, I'm sorry. And so he's had a lawsuit and stuff against all that and stuff before. So Woodhouse was being talked to as a potential witness to testify for prison conditions for the defense. So there's an accidental leak, allegedly. And I won't even say allegedly because the guy Woodhouse admitted it and then they admitted it in court. So we kind of know this one's already out there. But so Woodhouse comes on out on YouTube. He's saying that he has this. People can't confirm whether it's true or not or what he's doing. So so basically Baldwin is like, well, I meant to send this to Brad, and so instead of Brad, and ROZZI, I accidentally clicked on, Woodhouse because of his first name, blah, blah, blah. So the other thing is that Baldwin failed to actually report the Woodhouse link to the courts. And then Woodhouse, because of their YouTube and talking about this evidence and stuff. So he was contacted because of all of this. And even at the beginning, it wasn't like ROZZI knew about that even happening. So we have that piece. So we've got the press release thing. Then after the press release thing goes on there, she puts this gag order and stuff in effect. And that point, nobody can share anything with anybody, period. Okay. There can't be any behind the scenes after that point. Anything that was shared early on. So let's say Barbara McDonald or anybody else and stuff like that. Let's just remember, obviously there's information that shouldn't get out there, but you also have people who there's no gag order put in place. So since there's no gag order, somebody could be sharing some information with somebody, and that get out. Now, you also have to know whether that is true when somebody's telling you, and I'm not necessarily saying from Barbara McDonald, I mean from anybody who, if they're telling you they heard this from this person, is that true? Is that not true? Whatever, right? Some people want to make themselves more important than they are. So what is the worst part we have? So we've got the leak of crime scene photos that are protected by the protective order seal and the gag order. And that was because there was a continuous concern that the crime scene discovery stuff was going to get leaked. So allegedly, Mitch Westerman was taking photos of the crime scene photos while inside Baldwin's office that was openly laying out on a conference room table, not protected, not locked, and he could get access to it and took photos of these. Now, I want to remind everybody again that the photos that he had were photos of the altered photos that the defense made. Okay? They altered the photos. Okay? There were some altered, things done. So allegedly then, Mitch Westerman is sharing these photos following the timing of when the Franks hearing court is filing. Now, why is that important? Because they decide in the Franks hearing, which is only supposed to be, and I know I had somebody who questioned about this and whatever, and I've shown this, is only supposed to be about, we don't believe you had reason for probable cause. We think that law enforcement deliberately lied or misled or whatever to the court in order to get the probable cause, which means we want the probable cause thrown out and we want everything that was found during the search warrant thrown out. Okay, well, instead of it just saying that and just the accusations against the officers they were trying to say all this about, they decided to have this huge filing. And you guys remember how the tremendous amount of pages it was. And that's because in it, they mention Odinism theory, and they're basing it on describing in their interpretations. That does not mean that is solid what everybody thinks. They're describing in their interpretations of the crime scene. But they altered the crime scene photos were leaked, right? So if they're leaked, why do you have to alter them if it is what it is, right? Now, first of all, let's also think about something. This photo is a crime scene of children murdered that the family didn't know details about, that nobody knew details about, that the FBI, I did a short on that. Why does it matter about the crime scene leak? Because they talk about the only people who are going to know what the crime scene looks like are going to be the killer or killers, correct? And then you go and you leak it, and then you're not leaking the crime scene photo, you're leaking an altered crime scene photo that was leaked out that is trying to fit the scenario of that you're trying to make it look like that there is Odinism in there. Now, I didn't get any crime scene photos. I wouldn't look at any crime scene photos. I would not want to see any crime scene photos because also there is a girl who is nude, who, in my opinion, there was a sexual component to this. And it was not Abby who they were trying to, in their Odinism theory, Abby is the main person. It is Libby who is nude and killed the way she is and left the way she is, right? So you sit here and you alter it, and people have had, little sketchy things or whatever they go out. But the big thing is it's supposed to be wherever these sticks and stuff that we're laying is supposed to be completely in a different way than they actually were in the real photo, according to people who allegedly seen it or whatnot. So then we get from that point that allegedly Mitch Westerman, now remember, he is a co-worker, a friend of Baldwin. He's going down to the Franklin office. He lives up in Westfield, Indiana, which is in Hamilton County. He's driving down there. Baldwin throws him under the bus by saying, by the way, he's meeting his girlfriend down here, which Westerman is married and has 2 children, which, actually his wife filed for divorce in December. So he's going to be no longer married because of all of this that went on as well. I'm sure the girlfriend thing didn't help that. But so Westerman shares the alleged crime scene photos with Robert Fortson. And Robert Fortson was also in Hamilton County, lived in Fishers. And he distributed this photo allegedly to others, including Mark, who you heard about in Texas, who Mark is the one who then tried to reach out and share information with the murder sheet, asking them, hey, I will send this info to you if you'll share it with the police, and also stated that he has the messages that went back and forth of when this was sent to him with Fortson. They weren't just sharing a crime scene photo, though. They were also allegedly sharing what the strategy was for the defense team and updated of that. Now, how would they know those updated defense strategies? Now, allegedly, Baldwin is talking to Westerman and asking him and sharing with him about the trial and the details, although he's not a fellow attorney and he's not hired to work on the case, but this is what's happening. So we've got Fortson, again, who lived in Hamilton County. His family actually, main family was out of Kokomo that he moved out of from, but it's a family origin and stuff like that came out of actually Delphi. So he had family that was from that area and lived in that area too, in Delphi, Indiana. And so he also was sharing it out to others in addition to Mark from Texas, who ended up forwarding that and sharing that. And then Mark had shared that with some YouTubers as well. And so there were people who went on and were sharing this. And when this started to all get out about this happening, the Indiana State Police they go to speak to Robert Fortson. And when they go to speak to him, he sits here and he's like, he's going to talk to an attorney and stuff like that. And then basically after this, Robert Fortson commits suicide. And it is unbelievable that we have somebody that, because of this case and information that got forwarded out and sent here and sent there, and this crime scene stuff, that we have somebody who died. And I will say there's been other suicides that have happened in the area that people claim are related and stuff to that. And actually there could be a couple when you look at it, but when you talk about this, I mean, this one is directly related, could be related to that. And that's terrible. I mean, and it's following him finding out that people were, going on shows to share that they had this stuff. So then we go to the info about it getting out, about them investigating the alter crime scene photos and the leak by defense. Now, regardless if you think whether it's purposefully or accidentally. Now, there's a lot of accidents happening here, right? But if you believe it's accidentally, and Westerman did this all by himself and was going to go sit there and do that, regardless, there's a responsibility to protect crime scene and discovery. You already have that as period, regardless if there's a gag order or not. And then you have this case that's such a high level case, high publicity case, no matter what. But now this information being leaked and all this details of everything being out there now is sitting here. It's not just affecting, you wonder, oh, well, is that getting all around Indiana? Does this county over here maybe know about it? Well, how do you not know about it when we have people from different countries who know about what the heck is going on in Delphi and about Delphi? Now, is there going to be a pool of people who don't know about it? Sure, but there's going to be a hell of a lot of people who do. Why? Because it's not just being covered by local news, it's being covered by national news too. So let's look at this about when this report came out.
When Special Judge Fran Gall's court published this order Thursday morning, telling us next Thursday she will convene a hearing in her home courtroom in Fort Wayne, not Delphi, to consider, quote, other matters which have recently arisen, we didn't know what she meant. Now we think we do. Richard Allen is set to go on trial January 8th for the murders of Abby Williams and Libby German in the vicinity of the Monon High Bridge near Delphi in 2017. Weeks after Allen's arrest and first court appearance nearly a year ago, Judge Fran Gull of Allen County appointed Andrew Baldwin of Franklin and Bradley ROZZI of Logansport to represent him. Their full-throated 3-page press release defense of their client early on led Judge Gull to issue a gag order on all the parties, assuring the case against Allen would be debated in a courtroom, not in the media. But this past spring, there was an inadvertent leak of evidence from the defense to someone who posted it online, leading to a dressing down by the judge who gave Allen's defenders a second chance. But in the last month, amid a flurry of defense filings and state responses that have claimed withheld evidence and speculation about a cult of killers, another alleged defense leak has come to light, again to social media posters who claim to have sensitive crime scene evidence. Murder Sheet podcasters Kevin Greeley and Anya Kane have tracked down the leak and shared the results of their investigation with us. Some of it we've confirmed independently, which alleges a former employee of defense attorney Andrew Baldwin had access to the defense team's files and released that information to a man who then shared it with 2 other Delphi social media followers. One of them reportedly passed it on to other Delphi case virtual followers. The other called the podcasters and urged them to tell Indiana State Police, which they did, which would have been in the couple days last week before Judge Gull decided to call a special hearing next week to consider, quote, other matters which have recently arisen. What are the judge's options? At the very least, she can scold the defense and put them on a short leash, or she can fire Richard Allen's attorney, citing a pattern of defense leaks and comments and appoint new lawyers and no doubt delay his January 8th trial date. On an added note, investigators have also been advised of the unexpected death this past week of one of those individuals who was named as a social media Delphi follower who had access to the leaked information. In the newsroom, Russ McQuaid, Fox 59 News.
So next, a hearing is set for this coming up this Thursday. This time it'll be up in Allen County, up in Fort Wayne, where Special Judge Fran Gull is from. The purpose of that hearing is to discuss the upcoming hearing, October 31st. We'll have the latest for you on air and online at fox59.com.
Oops, sorry, I don't know why it wants to open it this way.
Special Judge Fran
Sorry
Gull
about that,
scored
guys.
public.
So,
When Special Judge Fran Gull's
I hate when it does that.
Special Judge Fran
So the contempt charges filed against the defense attorneys. So you know what happened from that. The October behind the scenes in the chambers discussion. She's going to address this stuff. Baldwin left. He said, you know, basically he was, I'm not going to be, you know, part of this. And he withdrew, verbally withdrew. ROZZI said he was going to withdraw, then he decided not to. You know, this is just totally obviously my opinion. I mean, I really get this feeling that, you know, ROZZI doesn't seem to be the person's office whose stuff keeps coming from. It seems to be coming from the Baldwin side. So I kind of feel bad for ROZZI if this is all Baldwin's doing and it's, you know, proven this is all happening here, then I feel bad for, you know, I'm sorry, ROZZI. I always want to call him that. I almost feel like his comment was just to me. So here we go. Another thing of the, and I hope I'm not replaying this. Maybe I am. Let me check. Sorry if I am here.
Carroll County Prosecutor Nick McLeland filed a motion that argues that defense attorneys Bradley ROZZI and Andrew Baldwin should be held in contempt of court for what he calls a trend of not being completely honest with the court. The prosecutor says the attorneys violated the gag order by issuing a press release proclaiming Richard Allen's innocence. He also points to information leaked to the public through Baldwin's office. Veteran defense attorney Ben Jaffe believes the prosecutor has outlined a strong case for sanctions.
When you got a gag order, when you have something like that, you have, you know, evidence that's sealed or something like that, you have to respect that. And the judge is definitely going to have to take a look at what kind of remedies are there to ensure that it's enforced and that people understand this is a serious matter.
ROZZI and Baldwin could face court reprimand, fines, or even jail if found in contempt by Judge Francis Gull. At the same time, the defense is asking that Judge Gull remove herself from the case, alleging she cannot be impartial after she accused Allen's attorneys of gross negligence and forced them to resign before the Indiana Supreme Court reinstated them.
And as much of a headache as this probably is for her, and this is not a fun case for her to be on, she's certainly not looking to, you know, get herself out of this problematic case or this very difficult case. I think she probably appreciates, you know, someone is needed on this with a lot of experience and someone that's able to sort of handle the personalities.
So if Judge Gull does not remove herself, Jaffe expects the defense to take this appeal right back to the Indiana Supreme Court again. Another longtime defense attorney told me today that Judge Gull should do the honorable thing and step aside. He called this case an embarrassment.
Yeah, so many twists and turns,
sure.
Rich. Thanks so much. It has been.
And that definitely is true.
Carroll County prosecutor.
I mean,
Carroll County
sorry about that. I'm getting better at it, but not that quick. So here's the other thing we have to remember. Every time the defense team has submit something, a new filing to the court, to get around the gag order, they keep including unnecessary theory details, accusations, or false information in each filing, including that Odinism theory. So, example, like I gave the Franks hearing, what it was supposed to include, they included 100 pages more that was going into this whole Odinism theory, which was not part of what the Franks hearing is. That's part of why the judge was pissed, because they did not file just the legal requirements of what the Franks hearing was. They decided to have this Odinism info in there, and that was a way to get around the gag order, because they know these documents and these filings are going public. So they put that out there, and then they end up getting that covered and talked about or whatever. They include statements. Now you're like, okay, well, how can I say that there's something that they say that's false? Well, because they're including statements of misinformation that is not true based on the probable cause affidavit information that we do already know. So there's some details in there that we already know in the probable cause details that we know is wrong, of what they talk about, for example, in the crime scene. They're trying to say a phone is found under one girl when we know the phone is found under another, right? So we know that the phone is found under Libby, behind Libby's back, under her back while she's laying down. And they're trying to say that the phone was actually found it was found under Abby. So they release this other details, because then people go, oh my God, well, look, now they're saying, which they did in these other documents that came out, the motion to compel, right? Well, when they file that, they're like, oh, well, there's this, and they found this, and then there's these other phones and this phones and stuff like that. Well, let me point out, the other thing you have to remember is that when Richard Allen finally goes and tries to get a hold of somebody, going through DNR, not calling law enforcement, but going through DNR, and then turning around and goes meets with Dan Dolan. He tells Dan Dolan, oh, this is where I was, this is what's going on. Dan Dolan's taking the information, takes it like he's a witness, not like he's a suspect, puts all this information in details. And what does he ask him to give him? He's like, okay, well, give me your information about your phone. So one of two things could happen with that. Either Richard Allen could be surprised and be like, okay, well, I have to give him this, hand him my phone that I'm with right now, and I'm going to give him the MEID number, because he had a phone number that did not have the IED, only an MEID. So he could have been surprised by that and realized that at the time. And or Richard Allen's not using the same phone that he used and had that day, which he could have had a totally different burner phone with him. And so he's not going to give him that burner phone. He's not going to still walk around with that phone that has that same MEID number. So the phone that he's walking up there with him, and suddenly Dan Dolan asks for that number, he can turn around and go, oh, well, yeah, here this is. This is the same phone I used that day. But as they're scanning, do they find a completely different MEID number that's there that they don't know who it is, right? Is there some other phone that's pinging that they have not been able to identify? So you have to realize, did he give him the correct phone MEID number that he had? And they're able to indicate, yes, we saw it on there. And if he gave them the wrong one, they would know, okay, well, we can't find that MEID number. It doesn't show that's in there. Although you have to remember the tower that's in Delphi and how close he actually lived to there. Can it be the same thing where we have KEGAN KLINE, where they're saying, hey, you're the alibi for Tony KLINE. He's the alibi for you. You're saying you weren't anywhere, but somehow you're saying you're at your grandparents' house, but we actually see your phone is at your cousin's house that's on Country Club Road, not on Paw Paw Road, right? And so that phone's not at your grandparents, it's over at your cousin's. And so, what's up with that, right? So there's info and details, though, that we know that the prosecution has released to us. And so the defense released stuff that's contradicting to that. And then they basically release info, which, by the way, I don't know if you caught on to when you listened to when Baldwin was talking by himself, he's like, well, in case, we get info out and other people can see, it's like a car people were driving that day. Well, he's giving hints about info and stuff right there. And by the way, how does he already have so many phone calls from, he's saying, first of all, from in the area of Delphi, but then he's also saying from around the country of people who are telling them when they've only been on the case in 6 days that Richard Allen is innocent, and they're going to share info and details with him, right? Based on that. So the other details, the prosecution cannot come back out and say and respond to the false stuff that's being said or misleading the public that is being filed in these documents, because they have to follow the gag order. They can't come back out and say this isn't true, because then they are violating that against Richard Allen's rights, right? They're violating that. But already you're not supposed to have the defense. It's a gag order. You can't keep doing that. So what's the disciplinary commission? I want to point that out to you guys. So we're going to know Monday what's going to go down. We'll hopefully get all the details of what evidence does McLeland have of what happened, how it happened, who sent what's going on, and God help us trying to read what this YouTube creator said, that this creator said, and this went here, and who emailed this, and who Dropboxed that, and who said what, and whatever. So after this all goes down, there can be a filing of lawyer misconduct complaint. Who does that go to? Okay, finding that stuff out, that goes to the Indiana Supreme Court, and that look at the disciplinary commission, and that anybody can file that. So, what complaints do they handle? And that's basically lawyers who must follow the Indiana rules of professional conduct, and that's what they check and look for. So all attorneys, meaning prosecutors and defense, must follow Indiana rules of professional conduct, and they will. They're updated as early as January 1st of 2024. There was an update to it. But when it talks about misconduct, professional misconduct of a lawyer to violate or attempt to violate any rules of professional conduct, knowingly assist or induce another to do so, or do so through the acts of another person, commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects, engage in conduct involving dishonesty, fraud, deceit, or misrepresentation, engage in conduct that is prejudicial to the administration of justice, state or imply an ability to influence improperly a government agency or official, or to achieve results by means that violate the rules of professional conduct or other law, knowingly assist a judge or judicial officer in conduct that is a violation of applicable rules of judicial conduct or other law. So this is the part in the information that, again, you can find under the rules and guidelines I've just showed you. So trial publicity, a lawyer who is participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing a adjudicative processing in that manner. Sorry, I have a hard time seeing out of one eye, so it's hard for me when I read this. Plus, this contrast is killing me in this documents. Notwithstanding paragraph a lawyer may state the claim, offense, or defense involved, except when prohibited by law, the identity of the person involved. So it basically just talks about contained in the public record info, a matter that stuff's in progress, scheduling or the step of litigation, request for assistance in obtaining evidence and information and necessary, so like a tip line, in warning of danger, concerning to the community. And it talks about in a criminal case, in addition to the subparagraph, they said the identity, residence, and stuff like that. So when you talk about the case and you talk about a criminal case, it really talks about information that can be said or cannot be said. And that's normally in a criminal case. But when you have a criminal case that has a gag order and protective order on the information, then that is a whole different type of thing. And, they are told to keep this, and they're trying to not prejudice a jury pool, right? Either way. And that you cannot say stuff falsely, and you cannot put information out there that is not true and is going to affect the trial. So criminal jury trials will be most sensitive to extrajudicial speech. So the rule sets forth on the base general prohibition against a lawyer making statements that the lawyer knows or should know that will substantially likelihood of materially prejudicing an adjective proceeding, recognizing that the public value of informed commentary is great and likelihood of prejudice to a proceeding by the commentary of a lawyer who is not involved in the proceedings is small. The rule applies only to lawyers who are or who have been involved in the investigation or litigation of a case and their associates. Another relevant factor is determining prejudice is the nature of the proceeding involved. Criminal jury trials will be most sensitive to the extrajudicial speech. And so then it talks about civil trials. So I pulled an example that was pulled, and I just pulled out pieces of it. And usually this is the can happen if the defense thinks that the prosecution is even speaking too much and they ask for it, right? So that's the motion for protective order prohibiting the parties, counsel, law enforcement officials, and court personnel from disseminating information or releasing any extrajudicial statements by means of public communication. So when we go to this gag order issued by the court, and what they're requiring is individual to refrain from making public comments. And the judge can issue that, barring trial participants, including attorneys, litigants, and witnesses. And we know that even the family is, right? They can't talk. Witnesses aren't supposed to talk. From discussion, trial-related material outside of the courtroom. In other words, a judge needs a compelling reason to issue a gag order. Well, why do you think she issued the gag order? They said they weren't going to go release anything. They weren't going to try it in public. And then what did they do? They went and not only kind of talked to them, which wasn't that much of a big deal, although they're already saying he's innocent and, he's innocent. We've only got this. We've only had 6 days, but there's nothing there. Blah, 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 blah. And then they did a written press release. You saw it in that news report. I've shown that to you in documents. They made a written press release. That's where it went too far, right there. Went against their word, period. So the judge can limit the speech of trial participants to prevent the dissemination of prejudicial information and to ensure a fair trial proceedings. That goes both ways. It goes both ways. So what is the gag order? The power for her to bar individuals from making public statements during the trial. And it is issued by the judge to prohibit that from happening. What happens if they violate it? Violators can face warnings, fines, and even jail time. This typically will depend on the level of the egregiousness of and frequency of occurrence and presence of malicious intent. Attorneys who violate gag orders can face additional consequences. Professionally, disciplinary proceedings may occur, potentially leading to them being disbarred. If they think that someone is deliberately disrespecting the court and tainting the jury pool, then the judge could do a lot of things. That was quoted by one of the people in here. So the additional extra judicial statements to news media is likely to produce a result of an undue prejudice in the community, so as to deprive the defendant of a fair trial guaranteed, and then by article, Indiana Commission and the 6th and 14th Amendments to the United States Constitution. Wherefore, the defendant, by counsel, respectfully requests the court enter a protection order directing the parties, counsel, law enforcement officials, and court personnel to refrain from making any further extrajudicial statements relating to this cause, and to refrain from further dissemination of information concerning this case by way of public communications, and for all other relief just as proper in the premises. So this was, again, the reading that I'm doing here is this is from a defense filing from that. So criminal defense attorneys are not allowed to share, distribute, and get others to help promote their case strategy and theories that should be saved for the jury trial. They can have all of this info, but this is what they present to the jury, talking about the Odinism and what happened and what's going on. That's saved for inside the courtroom, not out in public opinion and info. Especially, you can't be doing that when there was a gag order. How did that information sit there and get out there, right? Who is working with who? Criminal defense attorneys cannot have others promote to the general public their own theories, which can taint the potential jury pool. The Abby and Libby tip line received over 70,000 tips before Richard Allen was even arrested. The task force was set up of FBI, Indiana State Police, Carroll County Sheriff, and the Delphi Police Department, splitting up to teams looking into tips starting in 2017 and is still ongoing today. They believe there's more information out there of people who could be involved in some manner with the case, and they still want tips given to them about people who could be involved, and if you know something. And they had a lot of tips that started coming in once they also had Richard Allen, who was arrested. The defense may be saying about that from it, but we do know that there has been more tips that have continued to go in. They investigated and eliminated potential tipped-in suspects, then moving on to the next, and even started a new direction, remember, in 2019 when that press conference happened. If someone did not turn into a person of interest, they would have a written record about the tip they received and what they found and why they moved on for over these past 7 years. If there was somebody in there, why do you think they would move on? You're trying to say to me that they have so many people involved in covering this up that the FBI, the Indiana State Police, Carroll County, and Delphi are involved with it? So if you don't trust Delphi PD, okay. If you don't trust Carroll County Sheriff, okay. But now you're saying you don't trust the Indiana State Police and the FBI, who are investigating that and who also been conducting forensics, which they had to use in DNA forensics, any type of regular forensics, as well as electronic forensics. So you're saying that all of them are involved in covering this up. They're all Odinism. So what will we find out today during the contempt hearing? Does the prosecutor have evidence for contempt charges against both Baldwin and ROZZI? Somebody is lying, right? Somebody is lying. You've got all this stuff also going back and forth between, different what they want to call them, podcasters, YouTubers, some people it's podcast, YouTube. My show is considered technically, I guess, a podcast that's on YouTube, but whatever. What if the defense team is lying and is leaking the details? Where do we draw the line? They are supposed to protect their client. They are supposed to create reasonable doubt. But when it comes to ethics and what the attorneys are supposed to honor in the law is protecting the gag order and information and details. How do you know if Richard Allen is innocent or guilty if you have not heard the evidence yet? Not just the probable cause, but the discovery. We don't know what else is in there. Like I always give the example, don't watch the first half of the Dateline show and think you know who the murderer is, because then they follow up with the second half of it, telling you all the details they actually have against the person who ends up being found out that they did it. You're hearing all of this stuff only part. We all hear it. I want to hear it too. I want to know what more they have than just the bullet. If it's just the bullet and the ballistics, then I think the defense itself could argue that. But they're arguing very hard to get the probable cause affidavit thrown out for all kinds of reasons now they're blaming. And then they're turning around and sitting here and wanting that because then they throw out every bit of evidence that was found at the home or in the car. Everything would be thrown out. So remember what this case is about. What does it matter if somebody's lying or leaking info? Yes, protect your client. Yes, bring all these details to your jury. Have that in there. But if they are lying and they are leaking and they are giving details and they're having others promote their theory to the public, which is tainting everybody, what is this case about? They did not convict and find anybody else who committed the murders of Nicole Brown Simpson and Ronald Goldman. They did not find anybody else who killed Kaylee Anthony. Those are forever gone. And those trials happened in the public. And we got to see deliberate lies that defense teams made to protect their clients only because those cases were done in public and we got to watch the trials. This is happening when there's a gag order and we're not in trial yet. This stuff is supposed to be presented to the jury, not presented to the public. So somebody is lying. And what do we have to say about that? Well, there's only one thing I could think of when I saw that. So now we need to find out the truth, find out what is going on Monday, what details are we going to learn. And we need to stick with the facts. Let's all try not to prejudge. Everybody's going to have a bias. I understand all of that. But pushing a theory out there to help spread a theory that you don't have info, if that's what you think, if that's what your info is, there you go. But people trying to tell you and say, well, I know this because of this, or I know this is because of this reason. That shouldn't be what's going on, no matter what side. It needs to be a fair trial for we can get justice for Abby and Libby. There was never any justice for Nicole Brown Simpson and Ronald Goldman. There was never any justice that happened for Kaylee Anthony. And I don't think anybody who has followed this case or people who actually live here, we don't want that there is no justice for Abby and Libby. So let's make sure there's some integrity and honesty. Let's see if there's evidence today that's going to tell us whether this was purposeful leaks that have happened. And then find out what's going to happen because of it. And let's wait for judgment from knowing whether you believe Richard Allen is innocent or guilty. Let's wait to see the rest of that Dateline episode I keep talking about. Let's find out if it truly is, and more evidence in discovery that shows whether he did this or not. And let's make sure that we are making sure that justice is served daily. Please hit that like button. Please hit comments. Again, this is a pre-recorded show that's going out. So thank you for being here. Hit that subscribe button. Hit the like. And I'll see you on the other side of today's hearing of contempt. Good night, everybody.